Thank you for watching Life in Law with David and Ella Ham. This podcast is for general informational, educational, and entertainment purposes only and is not legal advice. David Ham is a Florida licensed attorney and member of the Florida Bar. Ella Ham is not an attorney and serves as the non-attorney office manager of Ham Law. Listening to or interacting with this podcast does not create an attorney-client relationship, and prior results do not guarantee a similar outcome. This podcast may be considered attorney advertising, and the hiring of a lawyer is an important decision that should not be based solely upon advertisements.
Hello, everyone, and welcome to our show, Life in Law with David and Ella Ham. Like you know, my name is Ella Marie Ham, and I am the Director of Operation of the Law Offices of David Lee Ham Jr. PA. And I want to take the time to thank you guys for joining us today in our 7th episode of the show. And for those who's asking, our law firm name is the Law Offices of David Lee Ham Jr. PA. Hello, if you want, our phone number is 904-307-3888. For those who don't know, our phone line is open 24 hours. You can call us anytime. We'll be glad to answer your questions. Mr. Ham, my co-host and also my husband, it is such a pleasure to have you with me today with the show. Hello, how are you?
Thank you, Ella. Thanks to all our viewers for being here. And we are very excited about the show that we're about to present, which is appeals in the appellate process.
Exactly. Before we get started, I want to say thank you to all of the viewers, all of the people who tune in, and all of the people who also decided to subscribe to our show. We're also going to be in Substack soon. If you're a Substack member, we're going to be mailed to you. For those who may be listening to us in their cars, also maybe in their house or maybe at work, we want to say thank you to you for listening, and thank you for sending to us those questions that you want us to answer. The show was created just for you because we want you to be able to navigate law, to know what's going on behind the scene with the attorneys, so you know the process of your show. Without further ado, we're going to start the show, and again, thank you for watching. It is our 7th episode, can you believe?
Of course.
Last week we have two of our member of the team here with us, and as you can see today, we are recording the show after hours. That's the reason why Mr. Ham is not in suit. He's usually in suit, so therefore he's more relaxed today. Is that true?
I'm not going to contradict you. That is correct.
Let's start with the show. Can you explain to the viewer what is an appeal?
Great. So an appeal occurs when there was a decision or an order in what we call a lower tribunal that was not a correct decision, and we need to demonstrate that there was some error that occurred. So it can be an appeal from a lower court, it can be an appeal from a government agency, and the questions I'm sure we'll get into that.
Exactly. The first question we have is coming from Lisa. Lisa is asking, if the judge ruled against me, does that automatically mean the judge was right?
Okay, well, thank you for that question, Lisa. And it reminds me of something I've heard Judge Judy say, and some other judges have said it as well, that I'm not final because I'm right all the time, but I'm right because I'm final. So in that particular series, she's the final authority. Those cases don't get appealed to a higher authority. Now, to answer your question, Lisa, judges are human, and judges sometimes make mistakes, and there may be some mistakes in a decision that a court makes. There may be mistakes in the processes that led to that decision. So we have to review the record and determine if there was error. And so there may be a grounds or a basis to correct a wrong decision made by a court.
Great. We also have Michael who asked a question that's not quite similar to what Lisa asked. Michael asked, can I appeal just because I think the decision was unfair?
Well, that's kind of a related question, and it's important to know that just the fact that you disagree with a decision that a court makes is not enough to appeal. There have to be legally recognized grounds for that appeal, which is why it's important to review the record and have a good, solid record to review.
Okay, good. Last. The third question, Amanda is the one who asked that question. So Amanda asked, can I introduce new evidence during an appeal?
Well, the simple answer to that question, Amanda, is no. There's not new evidence introduced to an appeal because appeals are what we call from the record. So the court is reviewing what record has been established, and they're kind of like looking back. We don't want to say like armchair referees. The other thing I want to point out is that it's not necessarily one judge that's going to be reviewing. Most often, it's a panel of 3 judges that review this record. So the appeal is very different from a trial. Some people may have that question, is appeal the same thing as a trial? No, they're not. It's a different process subject to a different set of procedures.
I hear that question often. People ask that question often. They said, is appeal basically a new trial? We should just answer. So no, appeal is not a trial.
Correct.
Can you elaborate a little bit about what is an appeal, what's going on in appeal, what is the process of the appeal?
So the appeal is to review the decision made below, and in order to review that decision, it looks to the record of what took place. That record includes all of the pleadings that were filed, the different things that happened, and during hearings, if those hearings were recorded through a court reporter, and there's a written record that is included, and there's the instance where none of that did happen, you didn't have a court reporter presence, that there's an agreement under the Florida Rules of Appellate Procedure. There can be an agreement for a writing of a supplemental record of what took place. So, to answer your question more succinctly, the court looks for mistakes. They're looking for errors, and those errors could be in the reasoning that led to the decision. Those errors could be in some procedure, either that was not properly followed, or there can be some other substantive issue concerning the law there that the higher court will then render a decision on.
Okay, great. The last time we have an appeal, not last time actually, one of the appeal that we had, that was from the Supreme Court of United States. So can you explain, because that's the book that, I call it a book.
Okay, well,
Can you explain what the different type of appeal, court appeal and all of those things?
Well, going back to your earlier question about what is an appeal and what's involved in an appeal, is what generally happens is we're looking at a written process. This is a process that does not involve calling witnesses and all of the things that were done in trial, presenting the exhibits. What happens is a written process in which the advocates advocate on paper in the various briefs that are permitted under the rules. So there are different sets of rules for state appeals, sets of rules for federal appeals, and also rules when appealing an administrative procedure. We did have a case in which we presented a brief to the United States Supreme Court. It's called a brief, but yet it's this
It's
very
a
thick,
thick
thick
book.
document. And so when you're briefing, you're laying out the arguments, laying out the applicable law, laying out the requirements as far as jurisdiction is concerned, et cetera, in a format for the appellate court to read through and understand in a fashion that's somewhat less dense than putting the entire record and saying, here you go, here's the whole record, which may be thousands and thousands of pages,
Pages.
but putting it into a condensed format. And that condensed format has to meet all of the rules
And
of that
requirements.
particular court. And so those local rules or rules of court are extremely intense when it comes down to font size, the number of words on the page, the number of pages allowed, all the type of font, all sorts of specific details that's very rule based. And so it's appeals can be very challenging, and
And very expensive too.
that contributes to some of the expense of appeals. Yes.
So next question, Carlos is the one who asked that question. Actually, no, yeah, Carlos is the one who asked that question, asking, how long does an appeal usually take?
Well, every case is different. It depends on the case, and it depends on a lot of factors that go beyond the case itself. So there are appeals that end up taking uh, years, and then there are those that end up taking less time. One of those factors, after all of the briefing is completed according to the timetable that's provided by the rules of procedure, the case is what we call submitted to the court, and the court uh, may take a very substantial period of time pondering that question. You know, if they're uh, new and specific questions that are unusual, or even if there's a usual question, a question that comes through, but the facts are a little different in this case, and then the court may take its time discussing amongst themselves. So remember I said there's usually like a three-judge panel. Those three members of a judge, they hold what they call a conference, and that conference, we've learned, may take place in person, or they may conference with each other by Zoom or what have you. But there's a process where their staff, or they have a good deal, a number of staff, they go through and do the legal research and so forth and present it to the judge, and the judge reads that and then comes up with their opinions and so forth. And each judge has different ways of
Doing
handling
things.
their matters. But then they get together, discuss, and sometimes they can't reach a decision. Or,
So what happened when they cannot reach a decision?
well, often what ends up happening in the state of Florida on state appeals, um, there is an affirmance. What an affirmance is that the decision below stands. If they've made a decision not to make any changes, or they could not reach an error or mistake, then the prior decision is going to stand. The decision below stands. But if they do determine that there was some judicial error that was made, then there's a variety of remedies that are available, which may include what we call remanding the case, sending it back, or sending it back for further proceedings
So
that are
is that a
consistent with
new
that.
trial? Is that
That's right.
when they have a new trial?
Possibly. There, it may be that, or depending upon, if there's just a question of law, then the appellate court might remand with instructions, specific instructions, just to make certain changes to the prior decision, in which case there won't be a need for an entirely new proceeding or a new trial. But there could be cases where a new trial is required.
The last time we had a trial, and then one thing that happened in the trial, those people were willing to appeal. Let's say that you get into a big trucking accident and then the jury award you $3 million, and the other party want to appeal it. What happened then? Do the person get that money, and then while the appeal is going on, what is the process?
Well, that's a pretty important question because in Florida courts and courts in general, if there's not a stay, what we call a stay of the proceedings, then that final judgment still can be executed on. And so when the appeal is taken, there's generally a stay that's requested, or there's a motion for stay, or there may be an agreement between the parties for it.
What is a stay?
Stay is stopping, and so when you stay the proceedings below or stay a judgment that was made in the court below, then it's stopped and there won't be execution. In order to obtain a stay, it's usually required that a significant bond be posted, which is usually the amount of the entire judgment. You're talking about a $3 million judgment, it may be a $3 million bond that has to be posted to do so. But it's very important to note that merely obtaining the verdict does not necessarily guarantee that the judgment is going to be paid.
Leah asked this question. The question she asked is, if someone pled guilty to a crime, can they appeal that decision?
Okay, so now talking in the realms of criminal appeals, now here in the state of Florida, where someone has entered a plea, that plea has to first be withdrawn in order for there to be an appeal of that, unless it is an illegal sentence. So illegal sentences may be appealed, but if the accused defendant, person who's been convicted now, decides that they wish to appeal that decision, they first have to have that plea withdrawn by the court, which opens the door to everything else. So if there was something that was obtained by virtue of that plea in the plea bargaining process, now they're exposed to whatever they could have been convicted of or sentenced to in the original case.
So, okay, that makes sense. So the next question that I'm trying to read the question the people send out, they send a lot of questions, and then we want to say thank you, because sending the question, that means they listen to the show. That's a great thing. So we do have a question from Heather. What is an administrative appeal?
An administrative appeal, Heather, is generally when a government entity or government agency, like your local zoning board or maybe your licensing agency, let's say that you have a particular license, issues an order that is for them a final order, and you exercise your right to appeal that to the higher board. If there's no longer any agency for that appeal, then the appeal may be taken to the circuit court here in Florida, and this is the lines of what we talk about as an administrative appeal. There are also administrative appeals on the federal side of federal actions, which may be brought to other district courts of appeal for that review.
So, Marcus, thank you, Marcus, for asking that question. Marcus is asking, can I represent myself in an appeal? If I have a business, can I also represent myself and the business in an appeal? So it's a two-part question. I don't know if you want to answer it that way.
Let's break it up into two. So there is the freedom to represent yourself, although it may not be most advisable to represent yourself. either at the trial level or at the
appeal
appellate level, because the expectation is that you know the rules that are applicable and you'll be held to the same standard as would an attorney who does the same thing on a much more frequent basis. Now, regarding representing your entity in Florida, the entities, except in small claims, have to be represented by an attorney. And so that applies to appeals as well.
So, so nobody, the person, unless it's a small claim, they cannot be represented, they cannot represent their entity with that. They have to be represented by an attorney, right?
Under Florida law, that's correct.
Interesting. That's, we're learning a new thing every day. Thank you, Marcus, for asking this question. The other question I have Emily, who asked it, why are appellate brief are so important?
Well, I briefly mentioned appellate briefs and what they are. They're important because this is what the judge considers, or the judges consider. They consider the briefs of the parties, and they may also receive what's called an amicus brief, which is a friend of the court. So you have amicus curiae, who are outside. There may be entities, maybe organizations, maybe just individuals who have an opinion, and they are basing it based off of their readings of law, and they can produce a brief to the court, but the court may also read and consider that in the particular case. So briefs are the written arguments, and they include all of the legal support, and it's what the judges review and rely on, as well as their independent study or their independent research, usually carried out by their judicial assistants.
So, another person, I think is Emily, who asked that question, asking why appellate, no, she's asking, does the judge hear witnesses? Actually, I got it wrong. I'm sorry, Emily. It's Kevin who asked that question. Say that, do appellate judge hear witnesses' testimony?
Well, this goes back to the earlier question that this appeal is not a trial. Now, I will say this, Kevin or Emily or whoever wants to
Kevin, that
know.
was Kevin who asked
All
that
right.
question.
I will say this, though, if part of the record includes witness testimony that was heard during the trial, or if this is an appeal that relates to a record that includes transcripts of testimony given during deposition, the courts can consider those. It depends on what is the type of question presented to the court and the level of scrutiny that the court is imposing. And so on appeal, there are different levels of scrutiny, some of which, when it's a pure question of law, for example, allow the court to review what they call de novo, which is de novo review, where they actually look at the same items that the lower court considered and review those de novo. Now, in other levels of scrutiny, they don't do that. They don't get to it. There may be what's called an abuse of discretion standard, in which they're only looking to see, did the court abuse its discretion, if there was such discretion. So what the court will see and review depends in large part on what is the standard of review.
Okay. Rapid fire question. Are you ready?
I am.
Okay, let's do it. State court or federal court?
It depends on the matter.
Brief written or oral argument?
Well, a written brief is what's going to carry the day, so brief writing over oral argument.
Okay. One word that describes the justice judicial system. Sorry.
Adversarial.
Okay, I thought you were gonna say complicated.
Well, that could be the case in some instances, but using the system, it is an adversarial system.
Okay. So are you ready for myth or fact?
It is.
You are? You ready?
I am.
You are? Okay, let's do it. Okay. If I lost my case, I automatically have ground to win an appeal.
Not automatically. Paul, it's a myth.
Okay. The second one is federal court follow different procedural rules than the Florida state court.
That's a fact.
Great. If I think the judge made a legal mistake, I should wait a few months before talking to an attorney.
No, not at all.
Can you elaborate on that for us,
that's
please?
a myth.
That's a myth. I know
That's
that,
a
but
myth.
how
Yeah.
long do you have?
Well, generally, most rules of procedure provide for 30 days in which to provide notice. So if you wait months, then you will
You lost.
lose, and it's absolutely usually a strict requirement that you do so within that time frame, or else you lose the right. So that's definitely a myth.
Okay, the next one is understanding your constitutional right before you need them can help you make better decision.
Yes, we talked about that previously. It will certainly help you make better decisions. It may not guarantee a particular outcome, but I would say that that is indeed a fact.
We are done. I would like to say that next week I would love to talk about licensure, professional licensure. What do you think about that?
I think that's a great idea.
So, because there's a lot of people out there who have issue with their license, they don't know what to do. We want to make sure that they understand that we do those type of cases as well, which is happen to be a civil, right? Am I right? That's a civil.
Well, administrative.
Administrative. Thank you for the correction. We are at the end of our show. We want to take the time to say thank you for sitting down with us. The show is for you. We want to make sure that you understand what the law is about. We want to say thank you for watching. We'll see you next time in our next episode. Until next time.
Your justice, our mission when life's challenges come.